Hello, my friends. I hope you're doing well. I'm attorney Hillary Walsh, and today I'm going to talk to you about everything that you need to know about petitioning for your family when you're a lawful permanent resident. My law firm is New Frontier Immigration Law, and I've been doing immigration law and only immigration law for over 10 years. And today we're going to drop some knowledge about how to get your family here if you're a lawful permanent resident. We're going to cover three things. First, the unfortunate circumstance that lawful permanent resident family members usually need to go through the consular processing process. That means you get your green card out of the country and come back in. I'm going to talk about an exception or two to that rule. So don't be discouraged if you're like, well, my family's already here and I really don't know what to do. There are a few exceptions to that rule. We're going to cover those. Second, we're going to talk about how lawful permanent resident family members are subject to what's called the visa bulletin. And the visa bulletin changes every single month. And it's kind of confusing, even for me. I still have a lot of trouble deciphering the visa bulletin, but we're going to walk through the very basics of it as our third part of this video. So, lawful permanent resident family members, as we get started on our first point, lawful permanent resident family members usually need the consular process. And that's because, as we go into point two, they are subject to the visa bulletin. So, if you are a lawful permanent resident and you're wanting your family member to consular process, there are a couple things that we can do. If you're wanting them to adjust status here in the US instead of having to go through the process in their home country. Here's an example, because we start talking about this stuff and it gets a little bit confusing because it's like talking about people based on their status. So let's talk about it this way. Let's say that you are a lawful permanent resident parent and you have a child who's over the age of 21. Your child who's over the age of 21 is now considered a son or daughter. And I'll show you this in just a minute when we go look at the visa bulletin. It's going to be very difficult for you to petition for that kiddo because they're over the age of 21. And so now they're subject to all these like longer waits. So whether they're going to adjust status or whether they're going to consular process really depends on whether you petition for them while they're in status. So in status in the United States. So if you're someone who right off the top of your head, you're like, no, my kid entered, my son or daughter entered and with a visa. So they had status at one point, but they overstayed that a long time ago. Then I know we're going to have to file a waiver for your kiddo so they can leave and consular process when it's time for them to do that. Okay. So if their visa is still current, so let's say they entered the country and they have 90 days on their visa that they're allowed to be here, and you petition for them during that time, you may be able to help them adjust status, which means to do your green card process here in the US rather than leaving. But pretty much all the time, I mean, I've done hundreds of these cases. Pretty much all the time, we have to consular process, which means they have to fix in their home country. They have to get their green card in their home country by going through the interview process there. Now, that's not a problem. Don't stress about that for most cases, if you're particularly if you're their parent, because you can help them with a waiver. But let's go into point two, because it's really going to help us see why it's so important for us to be really clear on the visa bulletin, and understanding it as its own animal. And I want to help you understand the visa bulletin today. So all I did, I'm going to share my screen now. All I did was, drum roll please, let's get over here, Google. I'll show you my Google. I Googled August Visa Bulletin 2023 because we are in the final days of July 2023 at the time of this recording. And they're going to release the Visa Bulletin usually about, 10, 15 days before the next month comes. And that's going to give you a heads up about the preference categories. So we're going to scroll down here to this section. So we're going to spend most of our time today is understanding what the family sponsored preferences are and understanding this first chart. There are other charts in here that are extremely relevant The second one in particular, if you've been waiting a long time, this one could be very relevant for you. And then this third one is going to be if an employer has petitioned for you. Okay. But today we're just going to spend time with this very first section, and we're going to break down and really understand what each of these means. And I'm going to use examples to hopefully help you digest this and understand how this impacts you and your family who you're wanting to petition for. So first things first, if you have status in the United States, you're only allowed to petition for a select few number of people. Back in the day, aunts and uncles could petition for family members, grandparents could petition for family members, and that's just not the case anymore. Aunts and uncles can't petition for anyone other than, their immediate family members. I think of it like a tree, and the tree has just a couple of branches. It can't be the little branches that come off of the main branches. So for example, you can petition for your kids. You can petition for your parents, which are not listed on this category because they're considered immediate relatives. And you can petition for your siblings. So your kids, your parents, and your siblings. You can petition for your step parents. If you got married, if your step parents got married before the time you were 18, you can petition for your step parent. You can also petition for your step siblings in certain cases. You can also petition for your step children in certain cases. So you kind of have a few breakdowns here that are not explicitly listed, but I just want to share that those are also options. So let's look at this. This tells us what the first category is. And the reason for these different categories, and we're going to go through all of this, so stay with me. The reason for these categories is the United States immigration laws have set up a preference system where more green cards are granted, more visas are granted to people based on your preference and also based on your country. So you're only allowed like 5% of all green cards are going to be distributed among the whole world. And that's why folks from China, India, Mexico, and the Philippines, who they have a lot of people wanting to immigrate to the United States because, we have a strong relationship with each of these countries, especially Mexico and especially the Philippines, because we're next door neighbors to Mexico, and we have essentially at some point really kind of almost occupied or really created a familial bond with the Philippines during various wars. So we created, people created relationships and families and had kids and spouses. And so lots of people from the Philippines have family members in the United States who want to petition for them. And that creates a backlog because we get more people. This is China, India, Mexico, Philippines. This is a reflection of the backlog for the 5% allocation to each country for visas. Okay. And then everybody else, if the person you're petitioning for is born somewhere else that's not these main countries, then you're going to see that usually the wait is shorter. Sometimes the wait is exactly the same. Like if you live in, let's say, Thailand, your wait is going to be the same as if your family member lived and was born in China or India and the Philippines, but it's still going to be longer if your family member who you're petitioning for was born in Mexico. Okay. Now, I will say that, you look at this and you can't help but notice that these are all countries that have people of color as their main demographic. And it just is another reflection of how the United States has a very racist immigration law system. So I apologize that is the case, but these are the cards that we are dealing with. And so we're going to soldier on and keep on trucking. Okay, so let's look at what the first category is. This is here in this top bar. The first category is going to be for unmarried sons and daughters of U.S. citizens. Okay, let's unpack this. They're unmarried. Does that mean that they're unmarried right now or that they've been divorced? If they have ever been married, then they are not in this category, and they instead would be considered married sons and daughters because at any point they have been married. So if they're divorced, then that means that they're still down here in this category. Next, we have sons and daughters. Sons and daughters means that they're over the age of 21. Otherwise, so they're 21 or older, I should say. And that's what it says right here as well to help kind of support that. Otherwise, in immigration law, they're called children. If you're 20 and younger in immigration law, you're considered a child. If you're 21 years and older in immigration law, you're considered a son or a daughter. So that's going to help us kind of with definitions and understanding who is what and where as we go along. Now let's look at this. First category, F1, unmarried sons and daughters of US citizens. What I will say is that let's look at this and see how much this impacts you. If, say, you're a lawful permanent resident and perhaps if you naturalize, would it help your petition process go faster for your kids? Okay. So right now we're going to compare unmarried sons and daughters of US citizens, first category, and we're going to compare unmarried sons and daughters of permanent residents, LPRs, green card holders, same. Okay. That's F2B. So if you are from anywhere, not these specific countries, a US citizen who petitions for their kids versus a lawful permanent resident, F1, F2B, the petition process is taking, what is this, like 9 years right now, 2015 to 2023, 8 years. Okay. I hope that's right. 2015, 16, 17, 18, 19, 20, 21, 22, 23. 8 years, American education system right here at work. We've got 8 years that it's taking for those petitions to become current. What does that mean? That means that if you filed a petition for your family member, for your unmarried son or daughter, and you're a US citizen, the petitions filed in 2015, January 2015, are now current and they can move forward in the green card process. Okay. It doesn't mean when it was approved, it means when it was filed. Okay. So if it was filed in January 2015, this is the time for you to begin your petition process. Your visa category is current. Now, by contrast, if you were an LPR and you petitioned for your adult unmarried kiddos, unmarried sons or daughters, then it's similar. 2015, they're just dealing with them in September. So you are 9 months ahead in the line than if you had been an LPR. Let's look at this if you are not, let's look at this if you're Mexican, okay? If you're a lawful permanent resident and you filed for your kid, your adult kiddo, it's August 2001 for you as a lawful permanent resident. But if you had naturalized and you were a US citizen, they're working on April. So again, just a few month difference. It's not going to make a substantial change. We look at this again in the Philippines, however, it's a year difference. Really, 9 months is the difference. And that's pretty substantial. This is an important thing to look at and to consider. And we'll go through this conversation and kind of contemplate this throughout this video. Because if you file your petition, let's say you filed your petition in 2015 and you later become a US citizen, your status has changed. It's going to bump you and your kid, the person you've petitioned for, if this is a spouse as well, it's going to bump you to a different category. And so that can be a time saving method to do in the 10 years, 9, 8 years that it takes for the petition process to be current. You can shave off a little bit of time. It's a long process. But like if you're running a marathon and you could shave off a whole mile of a 26-mile race just by becoming a US citizen, maybe that's worth it to you. So in this situation, it would be minimally worth it, but it would be worth it in my opinion. And dang, definitely worth it if you're looking at, a similar situation over here with October to March. I would absolutely say it's worth your time and energy to become a naturalized citizen if you're wanting to shave some time off and help get your kid here faster. You got to wait, that many years. Let's shave some time off by doing a relatively simple process of naturalizing. Okay, let's go down another category and we're going to look at spouses and children and unmarried sons and daughters of permanent residents. Okay, so this is going to be the second category. We've already talked about, they break the second category into two parts. That's F2A and B. Let's talk about spouses of permanent residents. And you'll notice here that spouses of US citizens are not listed. And that's because if you are a spouse of a US citizen, you are immediately eligible to get your green card you don't have to go into this long wait. So it is a big plus. And you're just not even on this page. Like, you are not subject to any of this wait. You'll see similarly, you're not subject to any wait if you're a child of a US citizen. If you're a young person, if you're 20 years or younger of a US citizen, you're not subject to any of this wait nonsense. So that's why it's so important to file for people, to file for your kids in particular before they turn 21. One way or the other, it's just a really big time saving component. Spouses and children of permanent residents. So spouses and children of permanent residents are down here in the F2A category. So 2017 right now, so that's like a 6-year wait for everybody else. And it's pretty much across the board, just a year longer, 9 months. Actually, it's 11 months longer if you're Mexican. Again, you can cut the line. You can get completely out of this category if you're petitioning for your spouse or for your kids if you just become a US citizen. And I know I say just become a US citizen. English may be a complicated language for you. I totally get that. But what I would say is you can learn English, enough English to pass the citizenship test in this amount of time. And you can help people cut the line. Okay. You can cut the line and you can become immediately current. But if you are petitioning for your children under the age of 20 or for your spouse and you're a permanent resident, it's going to take you this amount of time for your petition for them to become current. Okay. And they're going to have to consular process unless you file for them while they're in the country and their visa is current, like their permission is current, like their tourist visa, they have status, or they're on a student visa and it's current. If you petition for them, they could wait it out here in the US and you would be able to adjust status. Before you make that decision and go for it, though, because you're going to have to be stuck here for a long time, I would talk to a lawyer, because once you're stuck, you're stuck. Okay. You won't be able to travel, and that can become a really big problem for people. Okay. We already talked about the unmarried sons and daughters of permanent residence component. That's down here in the F2B category. Again, if your kiddo turns 21, they are just pushed into a longer line, basically. Okay. So, because as you see, once they turn 21, they become a son or daughter. They are pushed into this waiting line where if you were a US citizen and you had petitioned for them before they turned 21, you can save yourself all this headache and not have to deal with this, which is always a good thing. The third category is married sons and daughters of US citizens or divorced sons and daughters of US citizens. Again, this is adults, so 21 years or older are sons and daughters, and they've been married. At some point, they're going to be in the third category, and this becomes a very long wait. Now, you may ask yourself, and I'm just going to pause for a moment, and you say, why the heck is this? I don't know. I mean, on some level, this makes no sense from an economics perspective, because all of these are educated people. They don't have to come to the US. Married sons and daughters of U.S. citizens or of lawful permanent residents, you're over the age of 21, so you've already been through the school system in your home country. It costs hundreds of thousands of dollars to educate in the United States every single kid who goes through our education system. So another country has paid to educate this person, and now we want to bring them here. They're ready, and like they're the prime age to work and join the workforce and to raise a family and to spend all the money it costs to probably raise a family, assuming that if they're married, they might have kids. And they're all also going to want to work. It makes no sense to me. And this is something that is so broken about our immigration system, that we see countries like Germany completely doing immigration reform to get these exact people working and living in their country. And the United States is like, no, get in the line. There's like this line, you got to go get in. So anyway, it makes no sense from an economics perspective. And it just infuriates me, because I love my country and immigrants are like what's making it so great. But I digress. This is, again, the cards that we have been dealt. So this is what we got to deal with. Last category, this is a long one, is brothers and sisters of U.S. citizens. So brothers and sisters of U.S. citizens fall into this fourth category. And as you can see, If you're Mexican, it's a 23-year wait for that category to become current. And again, these categories change, and sometimes they do what means to retrogress, which is to go back in time. Instead of moving closer to today, they go farther back in time, and it's really a shame. So we see some retrogression happening here. Particularly this month, we've seen the visa bulletin retrogress. And for sibling petitions, it just takes a real long time. So that's where I always look at U.S. citizen, adult U.S. citizen siblings. This is like a bond. This is like a safety deposit bond where you buy it for $10 today, and in nearly 20 years, 15, 20 years, you're going to cash it in later. So it is a long game. But as soon as you turn 21 and you're able to petition for your sibling, absolutely do it. It is the longest petition process, but even if we're relying on your parents, I would still, because parents pass away in these long, long waits. Parents can pass away. So if your parent is a lawful permanent resident and they're wanting to petition for their kiddo, we're going to go into, I'm going to say, unmarried sons and daughters of permanent residents, because if you become married, there's no category for you for married sons and daughters of permanent residents. So you bump yourself out of a category and you're screwed basically. But unmarried sons and daughters, 21 years and older, F2B, and you're Mexican, you're going to be waiting for 22 years right now at a minimum for your parents' petition for you to become current. Similarly, you're going to be waiting 22 years for your sibling petition to become current. I would petition for you. Like, I would have both of you petition, because if you need this later on, it's going to be important that your petitioner is still alive. And when we're waiting 23 years for something, you don't want to put all your eggs in one family member's basket. I know that sounds terrible, but we've seen this happen where a petitioner passes away, and then like your options are just gone. They're just gone. So I hope this is helpful in understanding the visa bulletin. This updates basically every 30 days around the middle of the month, and you'll see what next month's is going to be. And if you're someone who's been waiting for the 245I process, they have bumped this back for Mexicans, for siblings. It's just taking a very, very long time. And I don't think it's going to get shorter unless we have immigration reform and our country just really wakes up. That's kind of all for today. If you have questions and let's say you're wanting to cut the line, you do not want to wait this long for your family member. You want to become a US citizen and petition for your spouse or your kids. You want to cut the line. You don't want to wait. You want to do this now, not in 5-6 years. You can reach out to us and we can help you with the naturalization process. But again, if you're thinking, but my kid, like, they've been married, I'm a lawful permanent resident, how do I petition for them? You have to become a US citizen first, and then you're going to wait in a very long line for them. I would recommend, if they're outside the country and they have any skills, meet with someone, like an employment immigration lawyer. I don't do that particular kind of work, but that's really your only other option, is to get an employment green card or an employment work visa to come to the country, perhaps while this dang thing is waiting for the next nearly 20 years. That would be my recommendation, is to look through the employment option so that they have a way. Because gosh, if you're Mexican, you probably have excellent skills, but you can't be waiting this long to be coming to the US. So maybe talking to an employment immigration lawyer would be your next step. I hope this is encouraging. I hope this is helpful. And I hope you have a really wonderful day. We'll see you soon here at Immigration Law Made Easy. I'm Attorney Hillary, and I'm here to help you. If you need anything, reach out. Thanks, friends.